I'm here along with my colleague, Julia Boisvert. We're the law firm Murtha Cullina. We're privileged to represent some of you. I've seen a variety of representatives of the various organizations that we work with. We work very regularly with tax-exempt organizations of all different shapes and sizes. And there's no client too big or too small for us. We work with organizations at all ends of the spectrum. So what this presentation is designed to be, and you can move to the next slide, Rob, if you'd like. It's really supposed to be high level. We're essentially having something akin to a fireside chat with you guys, just to sort of touch on these issues at a high level. It's supposed to be us talking with you, not talking to you. So if you have questions along the way, please submit those to the group, and Rob will if I'm going on a tangent or something like that, Rob will remind us that we've got a question. We'll be happy to take some time and talk through that issue. So we don't have a ton of time, and again, just bear with us that this is designed to be a high level conversation. So we want to, at the end of the day, help you sort of understand the landscape, so you know what the issues are, and not necessarily understand them fully, but understand what they are. We wanted to start with making some really high-level preliminary points to help frame this discussion. One is the goal of this. I mean, we can't eliminate risks. You get out of bed or you conduct your tax-exempt mission, whatever it is, there are risks associated with it. And we always tell clients not doing something is sometimes a risky proposition. So risks are there. They're there no matter what we do. And our job is to navigate them and to mitigate them, but never to eliminate them. We can't do that. The irony is, if you were to eliminate risks, that essentially means you've closed your doors and are not providing services. So the risks are part of life. There's internal and external risks. In other words, a lot of people focus on risks that come from the outside world and third parties. But in our job, in our practice, many times we're dealing with issues that have emerged from within the organization. And we're going to touch on where those risks come from, and again, strategies as to how we can mitigate those risks. There's monetary risks and there's non-monetary risks, albeit with monetary ramifications. What I mean by this is that, especially with tax-exempt organizations, it's very important to protect your reputation, your goodwill, workplace morale. There's a lot of risks that don't necessarily translate into money on day one, but they might translate into money and negative ramifications for the organization down the road. So we say that a lot when we're working with organizations looking at transactions or new revenue generating activities and things like that. It's not just monetary liability. It's also the potential risk to optics and your reputation and your goodwill. Intangible assets are extremely important to tax-exempt organizations. Another piece to this puzzle is, well, what are we really talking about? We're talking about, at the end of the day, you wake up, or at the end of the day, beginning of the day, you wake up, you have a limited amount of energy, a limited amount of resources. We want you to spend as much of those resources on your mission and your programs and activities, and as little on, dealing with messes after they come, or calling in professional advisors such as us to give you advice. It sounds ironic saying it, and perhaps it is, but our job is to help you proactively avoid risk and mitigate risk exposure, right? When you're looking at risks and making risk decisions, business decisions, essentially, I always ask clients to go back to the basics. Remember your underlying fiduciary responsibilities as management or as a director. You're not held to the perfect person standard, right? You're held to the reasonable person standard. And I've been looking all my life to be a reasonable person, but they do exist, at least in the law. But the idea is that our job is to help you make a reasonable decision that you believe, based on the facts and circumstances and our advice, is in the best interest of the organization. A lot of people think lawyers' jobs are to tell you no and don't do this, and have you considered the following, and slow you down. And that is not our job. And we pride ourselves as a law firm that is not designed to tell clients, no, you can't do this. Our job is to leverage our skills and our experience navigating clients through similar circumstances to help you take informed risks. And that is what your fiduciary responsibilities require. That not that you don't make a decision, or you sort of make a decision with a half, sort of half cock, shoot from the hip, but a ready, aim, fire approach. And when you make that decision, it's informed, and you're not judged with the results, but you're judged with the process that brought you there. So next slide. Julia?
Yeah, so today we're going to be talking kind of about 3 different areas and where risk might reside in those areas. So we're going to touch on a couple different governance topics. We're going to talk specifically about contracting and the different risks you can consider and potentially work to avoid when you're reviewing or drafting contracts. And then finally, relationships with third parties and how you handle your dealings with other people and other organizations. So next slide, Rob. Okay, so we're going to start with a general discussion about your directors and your board of directors and governance. So obviously your directors help to lead and provide direction for the organization. They're really your human capital, part of your human capital for the organization. And having a strong board, a good board, a board that understands its duties and obligations is really key to helping to guide the organization. But along with having a board, it comes a certain level of risk and liability, especially depending on who you are choosing to act on your board and the kind of guidance and support you're providing for them when they come onto the board. So part of good governance is creating a sound recruitment strategy for who you are bringing onto your board. So, one of the first questions you might want to consider and that we get discussion or questions on is how do you recruit directors for your board? Who should you be looking at? Who should you be thinking about? And part of the answer to that really depends on your mission. It'll depend on your size, and it'll depend on your goals for your organization. So a lot of organizations are looking for individuals who participate in certain fields. So for example, they might have an accounting background. You might be looking for somebody, depending on how active your fundraising arms are, somebody who's involved in event planning or marketing or something along those lines. Attorneys are commonly sought out for board of directors. But you want to be very conscious about who you are choosing and who you are looking to get on to your board. And in vetting those individuals, really making sure that they have a true interest in kind of acting as a fiduciary of the organization and understanding their responsibilities as a director coming onto the board. Ed, do you have thoughts specifically on director recruitment?
Yeah, I think what we're seeing actually, and I think it's a good thing, is a shift in paradigms from solely focusing on directors who are passionate about the underlying mission. And I'm not suggesting that you necessarily sacrifice that at all, but also bringing into the fact, like, what are the professional skills that we need on our board, right? And a lot of people are now putting time into almost like a checklist or a strategic plan to say, here are the professional skills that we are currently lacking. And our strategic perspective on the mission, the direction of the organization would be so improved if we could get a CPA on our board, if we could get a lawyer on our board, if we could get a financial, fiduciary investment management type of advisor on our board. So marketing professionals. So basically looking for directors who will leverage their underlying professional skills and to bring to the table. I think we're starting to see more and more of that, especially as organizations are morphing from seeing themselves as just mission-driven organizations to mission-driven businesses, and I think that's part of what helps you take that next step, investing in your board and putting thought into director recruitment.
Right. Yeah, I agree with that. And I think, there's a couple different ways that organizations will go about it. And, each has its benefits and potential weaknesses as well. Some organizations really make board recruitment something that the whole board is engaged in, while other boards, especially if you have a larger board and more active directors, you might want to specifically have a committee that's designed to really focus in on these issues and think about board recruitment. And along with recruitment comes orientation. So, I think part of what organizations really need to think about, you do all this work to find somebody great, to recruit them, to get them to agree to be on your board, bring them on, and then there's no sort of orientation that follows to get the director acclimated to the board, or to really truly understand how the board functions, what the organization's role is, or their duties and responsibilities in connection with the board. So board organization, I think, is a big part. Ed, are there specific features you think for board orientation that?
No, I mean, we commonly will come in and talk to our clients and present to their boards about, refreshers on what are fiduciary responsibilities, what we think best practices are for a relationship with management, and I mean, that's something that I'm dealing with right now, or we're dealing with right now for another client is there's allegations within the organization of certain directors being too hands-on with staff and being micromanagers, right? And that might be coming from a good place. They care about the organization. They're trying to make the organization better, at least in their subjective calculus. But a lot of times we get out ahead of those issues by making it clear to directors, you're at this strategic level. And if you've got concerns that relate to the operations of the organization, those really need to be filtered through the executive director. And you have to observe healthy boundaries at times.
Yeah.
So that's that kind of stuff where if you get out ahead of it, you avoid those situations which they occur. You really run the risk of alienating directors and potentially alienating staff. So I think that's something to keep in mind.
Yeah. And, another thing to think about too, when you're thinking about your board, is what kind of mechanisms do you have in place to make sure there is accountability for your directors? Obviously, you have accountability mechanisms in place with your staff, but director accountability is equally important. So, obviously you're going to be going about that in a slightly different way. So this will lead into our next conversation, but kind of a key place for director accountability might be within the structure of your bylaws. So think about things like the length of director terms. Does it make sense to have individuals reelected on an annual basis so that you're constantly kind of reevaluating the individuals who are serving? Or does it make sense to have a longer term so that there's sufficient time for the directors to really kind of get acclimated to their role and, provide a lot of value for the organization? Term limits might be another way to kind of think about director accountability. Making sure that you have a fresh board, people are kind of rolling off over a certain period of time. And then there's other things you can do, like creating a automatic removal in certain instances if an individual doesn't show up for a set number of board meetings or is showing that they're not going to be kind of actively engaged. Having those mechanisms in your bylaws can be useful for kind of ensuring accountability of the directors. So I think that leads us directly into our next topic, which is more specifically about the bylaws.
Right. Thanks, Julia. Yep. All right. So bylaws. They run the gamut. We've created sort of our own starting point for when we form new entities. And one of our guiding principles is, bylaws, do they serve the organization or does the organization serve them? What I'm getting at there is there's times when we'll inherit a client, have a new relationship, we'll look at their bylaws and we'll ask ourselves, do you actually adhere to these procedures? Do you have 15 different standing committees? Do you actually adhere to this notice requirement that's in here? And a lot of times people say, oh, we didn't even know that was in there.
Mm-hmm.
What do you mean? And there's this look of shock and saying, well, we haven't done it that way in decades. So sometimes, bylaws, they become this massively complicated set of procedures that frankly don't even fit the needs of the organization. And more times than not, they become a detriment to the efficient conduct of business in making internal decisions, right? So that's sort of your guiding principle. Make sure you have something that works, right? And if you look at them one day, which you should be, that's the review, refresh, repeat. Don't put them away in a drawer somewhere and never look at them again. I mean, look at them. And if you see something and say, why do we have this? And that's an archaic title. We don't have that office anymore. Or this committee hasn't met in literally years, or geez, this says we're supposed to have a minimum number of directors that we've now dipped under, those types of things happen, and better to catch them before there's a controversial issue in front of the organization than after. And I think that's what I want to really stress. All too often, people don't know what's in their bylaws. They don't know what their internal governance procedures are until they're in the midst of a significant issue. Either a controversial matter has emerged, a director might need to potentially be removed. A lot of times that's when people are looking at bylaws, when bad things have happened or there's controversial, significant decisions. We've had clients that have been looking at consummating a merger or a corporate affiliation, one of these big transactions. And they'll look at us of shock when we say, your bylaws say that you have members. Do you know who your members are? Do you have a members list? So again, it's good housekeeping. I'm not saying you even have to do it every year. I'm not saying you have to have a bylaws committee, but I do think it's important to keep an eye on them and to make sure on a fairly regular basis that, they fit you, and when I say beware lacunas, sometimes organizations will come to us and say, we're having a debate as to what the proper procedure was, or if this committee had authority to approve this action. And my first question is, well, is there something in writing, whether in your bylaws or some standing order or something like that? And they'll say, no, but it's been our consistent course of conduct. We've done it this way forever. And the bottom line of that argument is there is a legitimate position where you say, if we've done it a certain way, even if it's not in writing, that consistent uniform course of conduct basically fills in that gap, takes on the black letter effect of the bylaw. And what are bylaws? Think of it this way. They're a contract, right? So it's a contract principle. If parties agree to a deal, and here it's the directors and the members and the staff agreeing how the organization will be run, if there's a silence and, rather than saying, okay, well, what do we fall back on? And well, you fall back on course of conduct, but that's a less than ideal circumstance. If it's an important issue, you should consider having it fleshed out in the bylaws. I think that's the better situation. So with that, we can move to the next slide. No questions yet. I suspect some of you are out on the golf course or fishing or something like that. That's what I think. No, I'm kidding.
Yeah, I don't see any questions as of yet.
Okay,
Feel
we're
free
putting
to chime
everyone
in.
to sleep. That's what it is. So you can go next. Go next, Rob, if you don't mind. All right, this is one I'm having some fun with because now I'm talking about Zoom fatigue. That's one of the bullet points. For a while now, since the pandemic has been with us for over a year now, almost all clients have shifted to virtual meetings, right? And some clients are starting to shift into, I would say, even more of a remote atmosphere where they're now saying, well, we'll approve issues by email vote. When I hear email vote, the hair on the back of my neck stands up and I instantaneously get nervous. And the reason why is the Non-Stock Corporation Act, which is the statute most of your organizations are incorporated under, is pretty specific about sort of the two options in which your board can convene and act. One is either in person or through the use of technology that allows real-time participation. So that's Zoom, conference calls, Skype, whatever. So real-time participation. And then there's the unanimous consent option. And a unanimous consent, like it sounds, has to be unanimously approved. The old school way of doing this was to fax around or even send around a consent. All the directors sign it with their wet signature. They return it to the secretary. Now you don't see that. It's usually someone will PDF their signature back, or there'll be a way that they just respond to the email, their e-signature. But again, that's not a vote. That is an action that is taken in lieu of holding a meeting. And if you take nothing else away from this particular slide, please understand our perspective, which is admittedly, I guess, somewhat conservative, but I think very reasonable, is that there is no such thing as email voting because that's remote participation, right? That doesn't exist in the meeting context. A meeting needs to be real time. If you're going to do stuff by email, it has to be framed as a unanimous consent in order for the action to be duly authorized.
And just to chime in there, Ed,
Yeah, go ahead, Julia.
some organizations do have board portals.
Yes.
And so, we get the question a lot, can we do a written consent through our board portal? And that'll be fine too. Again, it has to be unanimous and you have to set it up to be in such a way that you have each director authorizing their electronic signature and approving the action, but that can constitute a written consent as well. So there's a lot of ways to get creative with the written consents. And, so it's about using the correct language and making sure you're doing it unanimously, as opposed to this idea of email voting, which doesn't exist under Connecticut law.
Right. And I'll be honest, and I'm admittedly sort of old school about this. My preference is always for clients to be authorizing actions in real time. I think there's a policy consideration behind all of this that says, and I'm not going to say better because that's not what it is, but a decision is generally more informed if you have people listening actively and participating in discussion in real time as they all collectively discuss the decision and weigh in and bring their professional skills and various experiences to the table. That's why unanimous consent is unanimous. The stakes are that much higher. When you're having a virtual meeting, it's, do we have quorum? And then it's generally what's a majority of the quorum that's behind the decision. So, lesser threshold as far as approval, but I think because the law recognizes because people are participating in real time, it's more likely than not that it's going to be a better informed decision, right? And I would also say, when people adopt something by consent, that's by its nature, it has to be a non-controversial issue, right? And we will generally always tell a client, listen, if this is at all controversial, if you feel that this could conceivably become an issue of debate down the road, have the meeting, discuss it at a meeting, because it's just going to fail anyways on the unanimous consent, and allow people to feel enfranchised and like they've had a voice, even if they're in the minority on the decision. Emergency bylaws, that's something that we heard a lot about when the pandemic hit. Honestly, emergency bylaws are this concept that basically was put into the Non-Stock Act in the event that there was like a nuclear holocaust, and there literally couldn't be like a meeting, or only like a handful of directors could be identified. That concept actually did come out of the Cold War. That's, if you look at if you're a nerd like me and look into the history of the concept, that's where it came out of. We don't have that issue, provided people have power and Wi-Fi, which, that doesn't always happen. But I don't find emergency bylaws to be really a relevant topic for most organizations, because you do have the means to have virtual meetings, whether it's by conference call or anything else. And as horrible and challenging as this pandemic has been, I think for the most part, all of our clients have found a way to have interactive real-time meetings. So to me, that's sort of a concept that should be avoided in all but the most dire circumstances. Now, I think the only thing is, I know we got to keep the pace up. I would just say, one challenge that I'm starting to have clients check in with me on is how do we monitor true virtual attendance? Because people will call into Zoom calls like this, and when everyone's sitting around a table looking at each other, it's sort of harder for people to nod off, because everyone else is sort of looking at each other and saying, oh, are they paying attention? Are they listening? I don't have a perfect answer for this, other than that I will tell you some clients have said, we really want to get back to having in-person meetings, because we're really concerned that people are just checked out. They'll call in and we'll see their little logo, but we never hear from them anymore. We don't know if they're even listening, so I think that there's some anxiety about how active or how actively participating directors are that just sort of call in, and how you monitor that. I don't know. It's like, are you going to submit a code or start calling on people randomly?
Yeah, and I mean, that might tie back to our first discussion about, vetting and educating your directors as well. So, if that does seem to be a problem with your organization, maybe you want to have a 2-minute refresher on fiduciary duties and responsibilities for the directors at the beginning of your board meeting. Just make sure everybody's kind of thinking about this and what their obligations are as directors, even in the remote context.
Right. And I did see a question come in. It's from Michael Ronson. It says, is the Non-Stock Act federal? Does it apply in certain states? So every state has the equivalent of a Non-Stock Corporation Act. So there is a model act, but Connecticut has elements of that. But basically the answer is it's a state-based statute, and every state has its own non-stock or nonprofit act or something like that. And again, I mean, to go backwards, which is the worst, not always the worst thing to do in these, your bylaws, when there are gaps, sometimes the answer is in the act, because the act applies to your activities and what have you. So sometimes that's part of how you fill the lacuna as well. It's not so much course of conduct. It's, well, what does the act say? So good question. All right, next slide.
Yeah, so the next slide, we're kind of thinking about this covers a couple of the areas in our chart. We're thinking about governance, and we're also kind of thinking about our relationships with third parties when we're talking about policies. So, policies can be written or unwritten, and we can be talking policies at the board level, or we can be talking employee policies. So, the first thing is, what are your policies? Are they being adhered to? Why were they adopted in the first place? So this is similar to your bylaws, in that any policies that you have for your organization, you want to be regularly reviewing to make sure they're actually being followed, and to make sure that they actually reflect the practices for your specific organization. So in the context of the board, two of the common policies that organizations might have, every organization we generally recommend have a conflict of interest policy that will govern any potential conflicts of interest among directors or officers, and provide a method for recusal potentially from any board decision where a conflict might arise, or in certain situations, if the conflict is so substantial that the director can't stay on the board, that can be addressed in the policy as well. So if your organization doesn't have one of these policies, I might recommend you take a look at that. There are other policies that are referenced in the Form 990 by the IRS, and that are mentioned by the IRS as policies that you might want to have as an organization. So one of those, for example, is a whistleblower policy, and kind of providing a mechanism for reporting any sort of concerns, potentially fraud, anything related to issues, breach of fiduciary duties or things like that, and how the organization will handle that. A lot of organizations ask, well, do we need all of these policies that are referenced in the Form 990? Our answer is generally that you should have a conflict of interest policy, and you should consider whether it makes sense for your organization to have these other types of policies, like whistleblower policies and the like. For some organizations, if you're large enough, and if you have actual processes in place to kind of govern these things, then maybe, yes, it does make sense to have these policies in place. But in many instances, it can be worse to have a policy that you're just not following and that you just don't use, than to not have a policy and to kind of govern situations in accordance with an unwritten course of conduct, if those situations are so rare for your organization. Another type of policy you might have, spending and investment policy. Ed, do you have thoughts on that policy or any of the other policies so far?
Yeah, I think I would just say it's the same consideration for your bylaws, that your policies should serve and reflect the needs and the real activities of the organization, and not the other way around. So I would, other than a conflict of interest policy, which you really should have in place, because there's language in the act anyways, it's sort of that comes into play. I would rather a client not adopt a policy that it really has no business implementing in the first place, or doesn't reflect the needs of the organization. I mean, if you don't have an endowment or a significant investment fund, then, I mean, query whether or not you need an investment management spending policy, right? Same thing with the document retention and whistleblower. Now, there's other, as Julia knows much better than I, because she's also a healthcare attorney, there are, depending on your activities, there's other types of policies that you have to have no matter what, like, the HIPAA policies and things like that. But, I think the guiding principle is don't just adopt a policy because there's a box on the 990 that says, do you have this? And we actually got an interesting question, Julia. I don't want to move along if we're still on the policies, but there was There was an interesting question that came in from Lori Bradbury. You want me to read it? You can take the first shot at it.
Sure, yeah, let me take a look at that too.
Don't sound so excited.
I haven't seen it.
It's
Go
a
ahead.
good one, actually. It says, we have a section in our bylaws about consent to action without a meeting. It says that the motion shall be passed either A, when all board members have unanimously so voted, or B, at such time as after noon of the third calendar day following the day, well, now I've missed it, of course. Following the day the motion was sent, a quorum of the board has voted affirmatively. Is Part B correct based upon the comment about Connecticut law requiring unanimous approval?
Oh, interesting question.
That is a really interesting one.
Yeah.
I like that. I have
Yeah.
some thoughts, but I want to put you on the spot, Julie.
Yeah, sure. So that is a good question. So assuming the organization is incorporated in Connecticut, if we're talking about an action without a meeting, which is specifically what we're talking about when we're talking about this idea of a written consent and a unanimous written consent. So assuming there's no meeting, the consent needs to be unanimous. So this idea that it would be, approved so long as a quorum of the board has voted affirmatively, that wouldn't be a way to be able to pass something without a meeting. If I think this is talking about a meeting, and for some way you're basically holding the meeting open for a period of time, that might be a way you can do it. That's a little.
That's a creative idea.
It's a little unique. And not a common kind of method, but assuming that's not what you're trying to do, if we're talking just about unanimous written consent, then A would be the way to go, and B, I would think is not an appropriate way to do it.
Yeah, I mean, just to muddy the waters further, there is language in the act, and I can't see Julia now, but she's probably rolling her eyes, but there is language in the act that I've always interpreted to be sort of an enabling statute that basically says, hey, unless the act tells you you can't do this, you can do it. You can agree to do it. In other words, it's like this freedom of association position that basically says you can conduct yourselves. You're a privately governed organization. You can conduct yourself the way that you think is best, as long as it's not again prejudice to the rights of the public or public policy or this stuff like that. It's a roundabout way of saying some people take aggressive stances to this stuff. I will tell you that I would be careful about using that. And if you do use it, then ratify that action at the next board meeting, to belt and suspender it. Because if it ends up being controversial down the road, people that are unhappy with a decision that was effectuated pursuant to that language, they could take shots at it and say, you know what, we don't even think that was a duly authorized motion, that was passed. So again, there's probably an argument, but it's an aggressive one if that really is being framed as an action in lieu of a meeting.
Yeah, Ed and I have a long-standing back and forth about that provision and whether it's something you want to rely on. But I think he's right. It's a risky proposition, and the question would be why do you need to do that in this particular circumstance?
And again, there's a good example. What's the risk that we're trying to navigate? Well, the risk is that the decision ends up being scrutinized, and there's an argument as to whether or not it was duly authorized. So our answer is not necessarily, no, don't do it this way. It's okay, let's think about this. Can we reframe the vote? Could you conceivably call a special meeting and have people participate virtually? Our job is to help you think of other ways to get to, okay, I mean, what's the reason you have this is you're trying to pass an action expeditiously. But again, it says, by the third calendar day, if you were to call a special meeting, I mean, most of our clients have provisions saying they can call a special meeting within 48 hours, right? So again, we'd walk through that with you and try to figure out what are the other alternatives that perhaps might be less risky to the organization.
Right. All right, and so just to wrap up on policies, like you mentioned, Ed, there are other potential policies like HIPAA policies that are going to be potentially mandatory for some organizations, those that have to abide by HIPAA. And then often organizations will also have, an employee handbook, some sort of employer policies. And again, kind of the key with this is making sure that you are actually following your policies. I can't say that enough for HIPAA policies either. If you adopt something, years ago when your technology was set up in one way and your technology has since changed, it's probably time to reevaluate those procedures and just make sure that they're actually reflective of your organization.
Right. Excellent. All right, next slide. What do we have now? Oh, donor restricted assets. So a lot of times, and this, there were a lot, I don't think the Connecticut Attorney General's office has released anything, but we've seen various, our neighboring state, Massachusetts has done this, release FAQs about donor restricted assets, right? Because when the pandemic hit and, before PPP and other resources were out there, a lot of people were looking at their restricted funds, their endowments and everything and saying, hey, is this a lifeline or is this forbidden fruit? This idea of, can we access this money even on a temporary basis through a loan or something like that to keep ourselves above water? Or is this really hands off? And this is not to be accessed, even if we're in dire straits. The donor restricted assets are out there, and there's a great, again, it's Massachusetts, the Massachusetts AG's office released a phenomenal FAQ about donor restricted assets that I think basically applies to Connecticut, probably 95% of it. One thing we always tell clients is don't create donor restrictions when you don't intend to. And what commonly happens is a client will launch a solicitation campaign, and the language of the appeal contains certain magical legalese, such as we're raising funds for an endowment, or we're raising funds for a capital campaign, the construction of a new athletic facility. Using that language and then soliciting donations that start coming in, even if there's nothing on the check from the donor or a cover letter saying thank you for using it. But if they're responding to that solicitation, you are automatically creating use restrictions or potentially endowment restrictions. And let me clarify those terms. An endowment restriction is when you say, what that means is we're going to preserve the initial value of that gift, in perpetuity, the principle of that gift, the corpus, and only spend the income generated by that gift. So endowment gets thrown around a lot of times. Some clients use it towards their board designated endowment, which are not true endowments because a board can release that endowment restriction anytime. These are donor imposed endowment restrictions, donor imposed use restrictions. All right, and they're easy to trigger without even intentionally desiring to do so. So who polices those restrictions, right? A lot of times clients will say, well, what do we need to do? Do we need to go to the donors and tell them, hey, this building project didn't end up being viable and now we want to use the assets for something else? And, the answer is a typical lawyer answer, it depends. But yeah, a lot of times that is what you need to do. If the donors are still alive, or if you can locate them, yes, you can go to them and ask them for their permission to deviate the use or free the restriction. A lot of times that's not an option. A donor has passed away or you can't locate the donor. If that's the case, the next step is to consider whether or not it's prudent to speak with the Attorney General's office. And we work with the Public Charities Division there, 2 Assistant Attorney Generals in particular, very frequently, have good rapport with them, and we'll walk through the hypothetical, usually we start as a hypothetical to get their input, because the Attorney General's office has statutory standing regarding all public donated assets. And that's the case throughout the country. So they become a necessary party in a discussion if it comes to the point where you want to change the use of a donor restricted assets or potentially explore lifting the underlying restriction as to use. Another thing we've seen from time to time, let me go backwards, I apologize. Be careful about how you access the Attorney General's office. I wouldn't go in there cavalierly. So that's something to be mindful of too. Use them when it's prudent to use them. Navigating unfulfilled pledges. We have had clients reach out to us from time to time and say, we had an agreement that this donor was going to give us, X million dollars. They only gave us Y million. What should we do? Well, it becomes a little bit of a business decision. If you've acted in reliance upon that pledge, there is case law that says you can go after the donor for the balance of the pledge. Question is it worth doing that? Spending the time, money, and energy to go after them and potentially not just alienating that donor, but potentially creating negative optics or bad goodwill or reputational damage to the organization. So, that is something that we run into from time to time. And again, to mitigate risk, a lot of times what we'll do is we'll work with the client to work language into the solicitation or the underlying donation agreement that proactively spells out what we can do and what we can't do, if the pledge is not fulfilled, for example, or if the use that was initially intended no longer is viable or reasonable. So a lot of times we try to deal with these issues, well, not a lot of times, we always try to deal with these issues proactively to avoid the potential controversy. Julia, anything you want to add?
No, I think that's right. I mean, making sure in the first instance that you're framing any solicitations correctly before they go out, and really thinking about, am I, imposing some sort of restriction on any donations we receive in response to this, I think is the big part of proactively planning for this. But I think that makes sense. And then the point about thinking strategically about going to the Attorney General is a big one. We've had people before who will just decide to go to the Attorney General and speak to them about some use restriction or some change that they want to make, and they don't like the answer that they get back, and then they're stuck with it.
Yeah.
So thinking about that, strategizing about that, really having a plan for whether or not that makes sense or whether there are other options, I think that's important to consider.
Right.
All right, so I'm going to do this quickly so we have enough time, I think, to talk about contracts,
Right.
Because I think that's a big one too. But for volunteers, this is an area we get a lot of inquiries about, because, volunteers can bring a lot to an organization and bring a lot to the table in terms of just manpower, in terms of energy, in terms of commitment. But there are also potential liabilities associated with having volunteers helping with the organization. So in setting up any volunteer program, you really want to think strategically and plan for how you are approaching that program before you just dive into it. So, potential considerations are, what activities are you having your volunteers engage in? Maybe it makes sense to have them assisting with fundraising, for example. So a lot of organizations might have volunteers join an event planning committee. Back when we used to have in-person galas, in planning those galas and things like that. But something like setting up a raffle or something like any sort of charitable gaming, that you might not want to delegate to volunteers because there are certain regulatory considerations that come with that. So charitable gaming and raffles, things like that, are governed by charitable solicitation laws in Connecticut, and most other states have specific gaming or raffle laws as well.
Especially with the advent of online
Yeah.
games and online charity events, it's creating, we won't get into the New York discussion, but there are certain jurisdictions that have basically said, yeah, we're going to adopt regulations to help guide organizations through online charitable gaming. And until we do that, you're not allowed to conduct online charitable gaming. So it's an interesting landscape for sure. But yeah, I agree with Julia. It used to be the jurisdiction of volunteers to conduct that, but now there's so much gray area, and there's actually some potential significant risk to organizations doing that. You want to be mindful of throwing volunteers into that without them getting the appropriate guidance, because again, it's one of those unintentional risks that you might create for the organization.
Right. So so just thinking proactively about it, what kind of policies do you want to have in place for volunteers? Is it appropriate to have a waiver for volunteers? A lot of, animal organizations, people fostering or volunteering at animal adoption events will have waivers, obviously, just kind of given the nature of animals.
Also, background checks is a big one now. We have some clients that are saying, should we be running background checks on our volunteers prior to them volunteering for the organization, because they're going to have access to minors and children and stuff like that.
Right.
I mean, that's, yeah, go ahead. Sorry. Go
No,
ahead.
yeah. So just, I mean, planning and thinking about those types of things, I think are important for any volunteer program. Do you want to move on to contracts, Ed, to make sure we can get to that?
Sure. 5 minutes. Five
I
minutes
know,
for contract.
I know. We can
Yeah,
talk
and
about
again,
any
I
of
mean,
these
Rob, I
topics.
don't know if listen, if you want us to hang around, I don't have anywhere to go right at 3 o'clock. So if we want to go a little later, that's okay with us. But
Yeah, absolutely. Not a problem.
okay. And we won't fault people if they drop off, if they have got plans, it's fine. I just don't want to shortchange the group. Contracts. So the first bullet point is to highlight something in that, you know, we have clients that are of the mind, hey, if I trust the third party on the other side, I don't need some massive, robust contract to think about every contingency or potential thing that might happen. I just need a handshake. I've done my diligence. I trust this person. You know, don't drive me crazy with some massive contract with boilerplate and all this legalese. Then we have other clients that they err on the side of throwing the kitchen sink at a circumstance, and they will adopt a contract that is so lengthy that at times you get bogged down into the negotiation of the contract and you forget some of the material big picture issues. You know, do we have a well-defined scope of work here? You know, or are we really, you know, looking at provisions that are more than likely never going to apply to us? So I think, you know, there's a happy medium there. And that might sound bizarre, an attorney telling you that, but based on the circumstances, it's not, you know, the goal is clarity. The goal is to have something that makes sense, that both sides understand. And I push for simple, less is more. Sometimes you need to tackle certain regulatory issues in there, and you do need to have certain boilerplate, and it's important boilerplate. And we can talk about some of those things in a moment. But, you know, having an extremely long, robust, wordy contract is not going to substitute for having done decent diligence or asking hard questions or negotiating some of the more controversial points of the particular relationships at the front end. So I would just say, you know, be mindful of that. I think that there's a happy place there.
Yeah, and just to chime in on that too, you know, I think it also depends, again, you know, Ed said this, but the specific type of contract that you are doing. So if we're talking about a 1-year contract for the operation of a small program, you know, maybe talking about $50,000 or something like that, maybe a simpler agreement will be fine. But if we're talking about a, you know, electronic health record contract or billing contract or something like that, that's designed to be 5+ years and hundreds of thousands of dollars, then, you know, the level of detail you're getting into and you're really investing in putting in the contract is important because, you know, even if you've done kind of your due diligence up front, which you should always do, parties might change during the course of those 5 years. And somebody coming back to review something on the contract might not be someone who negotiated it or understood it in the first instance. So again, it's all about thinking about what is your particular risk for this particular situation.
Right. And I think some of I called it boilerplate, but I think these are important provisions that a lot of times people say, it's boilerplate, throw it in there. And, you know, we don't need to really look at it or understand what it's even getting to, but these are really important concepts. You know, one is the concept of indemnification. And that's really, you know, if something goes wrong pursuant to the terms of the contractual relationship, and the responsibility for that bad thing that happened falls on one party but not the other, and there is a lawsuit or some, you know, loss that emerges, then that requires the party that made the boo-boo to step in and pay for the costs that the other party, the party that was part of the contract but not involved in whatever the accident or damages were, to pay for that party's expenses, you know, including legal fees. Indemnification, though, is very important to understand. That happens generally after the fact. So once the trial has already been held or it's far along in the process, that's not the same as insurance. You know, insurance is different in the sense that, you know, with a lot of caveats regarding whether or not there's an exclusion or a premium or things like that to be paid in the first instance, insurance steps in and pays proactively, sometimes towards a settlement and then also towards legal fees. Now, insurance is not a perfect solution, you know, for managing risks. And we work with, including insurance provider group, obviously a little pitch to them. work with some of the best brokers out there, including the Schuster Group as well. But it's not perfect. So few clients take the time to understand what their insurance coverages cover and what they do not. Exclusions matter. I want you to understand that. And I think also a lot of clients will say, okay, well, we want this other party to put us on their insurance as an additional insured. And a lot of times they'll say, well, how do you evidence that? How do you know for sure? Well, here's a certificate of insurance. Well, guess what? A lot of times the certificate of insurance, or most times, it'll have something on it, this big disclaimer saying this does not definitively or reliably say what is included by in the policy. This is essentially a big disclaimer saying it's not really worth the paper it's printed on. So that's something to be mindful of. When you talk about insurance coverage, understand what the exclusions are, and ask to see the actual policy or a letter from the broker or something like that, certifying or acknowledging that you are indeed an additional insured on the other party's insurance policy. It's not always enough to get that little certificate of insurance. Other provisions that matter, termination.
Yeah, and sorry to interrupt.
Go ahead.
But,
No, go ahead.
So, one reason we really did want to talk about these contractual provisions is that oftentimes, sometimes we'll be asked to review certain contracts. Oftentimes our clients will be kind of reviewing and negotiating contracts on their own. The indemnification and insurance language can be very tricky language. And it can, a lot of people will just kind of read through it quickly, think it's boilerplate, and kind of move on from it. But that is really one area you want to pay a lot of attention to. And in some instances, again, just depending on the level of the contract, the importance of the contract, and kind of the potential risk associated with the contract, even if you don't want an attorney to review the entire agreement because you think you're capable of handling that, that might be a provision where you want a certain amount of backup. Because with just the change of a few words, you can really shift a lot of responsibility for liability related to certain actions under the contract. So just to highlight that even further.
That's a good point. Termination is such a crucial provision, and not a lot of people want to be thinking about terminating a relationship when you're in the processes of negotiating and entering into a relationship, but it's very important. People they sometimes get into the weeds as to what constitutes cause under the arrangement, but really the focus should be on, well, do we want to just say termination without cause? So maybe the relationship is just not, if it ends up just not going great, people may not be in breach, but they're just not doing a great job. Let's build in flexibility where either party can terminate, without cause. That might be imprudent depending on how much resources you're putting into the arrangement and everything else. But termination is an extremely important provision. This idea of what's our exit strategy if this relationship doesn't end up to be the positive experience that we're hoping for. Some clients push for a long initial term and they make it very hard to terminate the arrangement because they realize we're investing a lot into this and we're not going to realize the advantages that we're looking to realize until we're a year or two into this arrangement. So we really do want to lock in the other organization. Other people take the opposite approach depending on the circumstances. They make it so that it's relatively easy for them to terminate the relationship and for the parties to go the other way. You want to add anything to that, Julia, regarding termination provisions?
No, I think that's right. Just when you're thinking about termination too, make sure you're aware of any sort of obligations on termination. Depending on the contract, there might be some sort of basically early termination penalty. So thinking about that in advance and making sure you're negotiating that to a reasonable level is important to consider.
Yep. Force majeure, which is sort of the act of God provision. And candidly, this was like talk about a throw-in. I don't think people really paid much attention to this at all until we had a global pandemic, and then it became a very relevant provision. And now the amount of newsletters and business finance department discussions we've had of the nuances of force majeure provisions, I mean, it's become a very important provision, and just query when you're entering into a relationship, what a force majeure is basically saying it's excusing the parties from performing. It's basically saying something happened that neither of you could control, and you know what, you guys could just walk away. That's essentially what this provision has said. It just basically says the contract is impossible to perform under, and people have been really careful about what constitutes force majeure. Now that I think we understand, and I think bear in mind this goes to people's resilience and their ability to adapt. It's possible to continue to perform even during a pandemic, albeit perhaps with modifications or things like that. So I think people have approached defining force majeure events very carefully, and I think most people see them as not necessarily an excuse to stop performance, but it's something to take into account and potentially bring the parties back to the table or otherwise modify the agreement, but not just to walk away from it. I think that's what I would say. Julie, I don't know if you have anything else to add to that one.
No, I think that covers it.
So dispute resolution, again, not something that you want to be talking about when you enter into a contract of a new party. I mean, everyone's excited. You're saying, oh, we're going to 2 + 2 = 6. We're going to have this great relationship, but it doesn't always work out. And if there is a dispute, we generally advise clients, don't go from 0 to 60. Maybe start with a mediation, which is a way for the parties to, or not even a mediation, a cure remedy. In other words, hey, we've got a breach. You've got a cure period, and if you fix it, we will move forward on this, and we'll keep on going. If there is a dispute, and if there is a dispute, then the issue there is, we start with mediation where it's not necessarily binding. It's two people getting into a room and hashing it out with a mediator and just trying to come to a compromise or settlement of the issue. Then there's arbitration, which is you're in front of an arbitrator who can resolve the dispute, sort of like a judge, right? And the old way of thinking was arbitrations are more cost effective than trials, although now our litigators are telling us that's not always the case, which is hard for me to imagine, but I'm not a trial lawyer and I don't, represent organizations in arbitrations, but something to be mindful of. And so again, I guess what I would say from a drafting perspective, do pay attention to it. And we have some clients, they'll sometimes sign an agreement and then something isn't going well. And they're shocked that there's a provision in there saying, if there's an argument, then the remedy is court, and you've got to fly out to, I don't know, Timbuktu, Minnesota or something like that, because that's where the venue is. People play that game where they'll say, if we're going to have a dispute resolution, we're going to make it really difficult for you to actually facilitate the dispute, So that's something to really be mindful of. What does it mean if there is a dispute? What are our remedies going to be? And are those remedies going to be so onerous or so costly that we're not even going to pursue them? We're not going to utilize those remedies. But again, from our standpoint, we like to not escalate the situation from 0 to 60. We like to provide the parties a roadmap for trying to work through what the issue is. That's generally our approach.
Yeah, that's right. And you want to think carefully about this provision too, just in terms of whether there's anything you do need to carve out of your dispute resolution provision.
Excellent.
So for example, non-competes or non-solicitations, if that's something you are specifically including in your contracts, you don't want that subject to an arbitration or to a mediation generally. You want to be able to go to the court and get immediate equitable relief. So that would be something you generally carve out of your dispute resolution provision. So just being.
It's an excellent point. There are certain things where you want to reserve the right to go to court, and injunctive relief is one of those, definitely one of those things. So excellent point.
All right, last slide, Rob. So just to touch on this briefly, I know we're already over time, and we have done presentations on strategic collaborations, and I'm sure we will do more in the future. They're a whole presentation in there on their own. But just in terms of thinking about risk and managing your risk, kind of the key point here is making sure that before you are getting into any sort of strategic collaboration, or even getting too far down the road into any strategic collaboration, that you are really doing your due diligence upfront to make sure you understand who you are dealing with, whether there's any, what sort of cobwebs there are in the corners and in the closets of that organization, because you don't want to be taking on liabilities that you're not already aware of. Once you find out what the liabilities are, they might be something you're okay with and you're willing to take on. But making sure you understand that first is truly important. There's things like, making sure as well that you understand any sort of obligations that are associated with entering into the transaction. So regulatory issues, licenses, can those transfer? Do you need to get new ones? Third-party financing, are you going to have any issues with getting consents or approvals from lenders, consents and approvals from major funders or under major contracts? All of this is part of due diligence, and all of it is stuff you can kind of explore before you get too far down the line again. Once you do eventually complete your transaction, part of the hardest work that you do in connection with a transaction is after the transaction is complete.
Right.
So again, it's about proactively planning for that. So how are you going to integrate your staff, the new staff coming on to the organization? How are you going to integrate them into the organization and into the culture? Similarly for board members, if you're taking on board members of the old organization in connection with the transaction, how are those individuals going to come onto the board? Again, what training are you providing? What type of orientation is there? So, again, kind of the focus for this, I think, is make sure you're doing your upfront planning in certain key areas. Ed, is there any high level thing you want to hit on this?
I would just say don't underestimate the emotional component to these transactions. And, at the end of the day, these strategic collaborations, it's not about, one party trying to sell for a high price, the other party trying to buy for a low price. The currency of these deals in many ways is, things like board seats, or, if one organization is being quote unquote acquired or otherwise taken over or merged into another organization, are you going to negotiate post-closing covenants to preserve programs that are very near and dear to your organization and your donors and stakeholders? There's a big emotional component to these deals, even though money, so to speak, is not on the table. So make room for that. I think it catches a lot of clients off guard until they're sort of in the weeds of a transaction and negotiating. And I think, part of that is a byproduct of the fact that you're very passionate about what it is that your organizations do. You care, right? And directors care too. Many times directors who are on the committees negotiating the transaction and interacting with us, they're as fired up as anyone else, or more so, to the point where sometimes you have to tell them, oh, if you really think that's such a great idea, then pass the hat around and the board can pay for that particular due diligence or something like that. So it's another example of where you sometimes have to make room for those emotions, but also take a step back and keep things at a business level, I guess is one way to put it. So and boundaries come into play with that stuff too. So.
Great.
All right. Well, we covered so much, and I know that there's a lot we would have liked to have said, and thanks for those of you who are hanging around with us. If we didn't cover a particular topic of interest to you, or if this presentation triggered questions for you, please feel free to reach out to us. We'd be happy to talk to you. And thanks for taking the time. And Julia, you want to send us off? Any final comments?
No, I think that's great. Yeah, you have our contact information. Please feel free to reach out if there's anything that's unclear, or if this prompts something in your head after you sign off for the afternoon.
Great. Well, thanks, everybody. And just wanted to give you a heads up. Thanks, Julia, and thanks, Ed. That was a lot of information, and our partners are here for you, so you can certainly reach out to both of them. And we will, if they're okay, send out a copy of the presentation. And we have our next event is actually called 2021 and Beyond Emergent Retirement Plans and What You Need to Know. And that's taking place on April 28th. So feel free to join us. You can go on the website and see all the events that are coming up. And once again, we'd like to thank you, and stay safe, and we'll see you next time. Thanks again.
Thanks.
Take care, everyone.